This lecture deals with the second public forum resolution option for September-October, which addresses the question of whether or not schools should be allowed to regulate off-campus electronic speech. The resolution option is, resolved, United States public K-12 schools should be allowed to regulate students' off-campus electronic speech. What is this resolution about? It's about a few different things. First, it's about free speech. After all, we're talking about speech that students are engaging in off campus, and we have a First Amendment right to free speech. So it's also about students' rights, and not just kind of generally subsumed under the First Amendment, because of course students have a right to speak, but that speech can be constrained in an educational environment, and we'll be discussing that. It's also uniquely about online speech, and we'll discuss some facets of the topic that are relevant to speech that occurs in school and the legal precedents that stem from that, but really dealing with exclusively online and off-campus speech. You also will discuss school security and school bullying, because that's really the type of speech that threatens schools. Bullying threatens other students, threats against the schools, making fun of teachers, disrupting the educational environment through online speech is really what's at issue here. If you debate this resolution, you will learn a lot. You will learn about your free speech rights in school and how the law applies. You'll learn about how the courts work, including the Supreme Court, district courts, and state courts. You'll learn about standards used to assess the merits of student speech, both on and off campus. And you'll learn that it's difficult, but not impossible, to be caught on this resolution. In today's lecture, we'll cover the terms of the resolution, controversy in background and court cases that are relevant to the topic, as well as the major pro and con arguments. The terms in this resolution are relatively easy, and that's something that attracts people to the resolution. Though, as I will explain, I think the substance of the debate is as complicated or more complicated than the first topic. But let's hold on that for a second, and let's just talk about the terms. The United States simply refers to, of course, this country, the United States of America, and it's really kind of talking about U.S. constitutional rights that are at issue here, since the resolution directs the discussion towards the United States. We are dealing with public schools. We're talking about public schools or taxpayer-funded schools that anyone can attend. This is very significant because, first of all, employees of the schools, particularly administrators, are considered government agents. And the Bill of Rights, the first 10 amendments to the Constitution, really protects individuals against the government. All right, we're talking about free speech. Sometimes this is misused when somebody gets fired from their job, from a private sector job, and they say, my free speech rights were violated by my employer when they fired me for saying something. Well, no, that's not. They didn't violate your free speech rights. You may think you should be able to say what you said, but they can't violate your free speech rights. The free speech rights come from the government and come for protection against the government, not against a private actor. Which also makes kind of the question of private schools irrelevant, because any school can make a contract between the student and the student's parents and then of the student. Where the student agrees to certain regulations. For example, they may have to agree as a condition of attending the school. They may have to agree to certain restrictions on their online speech. K-12 refers to grades kindergarten through 12. And of course, we're not talking about universities here. There are a lot of controversies related to online speech at universities that's arguably off campus, but that presents some different questions, primarily because you're not dealing with minors. You're dealing with people who are over the age of 18, and schools have different responsibilities towards minors than colleges and universities have towards adults. The next terms in the resolution are should or should be. Should simply means ought, which is worth mentioning here, can sometimes include a moral obligation, which teams may argue about, that there's a moral obligation to police off-campus online speech. And I should say that it's also in the passive voice, should or should be, which means that the affirmative or the pro can defend the status quo. And, usually a resolution doesn't require a policy change. You can defend the status quo. But in this case, that's very important because in the status quo, schools are allowed to regulate to a degree off-campus online electronic speech. Allowed simply means permitted, not that they have to do it, but that they should be allowed to do it. Electronic speech, you're generally dealing with the computer, something that's kind of written on the computer and communicated through the interwebs. It's obviously mostly kind of irrelevant if the speech is not communicated in any way, but that it's then speech, it's spoken or written. They're talking about something that's spoken by a student, written by a student, maybe through a text message or just through a website that's posted online or through a blog. You could really kind of list out a number of different ways that electronic speech could occur, but I think it's something that's kind of pretty easy to understand. Now, off-campus is a little more difficult, and it's really the reason that the controversy even exists in the first place. The reason it exists is because it's hard to separate what occurs on and off campus in terms of kind of people text messaging each other. Are they doing that on or off campus? And this maybe they're writing a web page that demeans a student or a teacher at the school. They may be doing that at their own house, but that obviously has on-campus implications. So the reason we have this controversy is because we can't tell exactly what's on and off campus. So clearly your home or your apartment and your own computer. If you're producing a blog online at your home or apartment using your own computer, that's clearly off campus. But what if you print that out and bring it to school? That becomes on campus. Or what if you access it from a school computer? Or if an administrator accesses that from a school computer? What if you access it from your phone in school? Right? So you can see that there's all kind of gray areas here about on campus and off campus. And you can see from this quote, a school's responsibility doesn't end when the school bell rings, ending classes for the day. The line between the home, school, and work have become so blurred in recent years, and they could eventually become non-existent in the not too distant future. Excuse me. So what this is talking about is really just that, what I said, that this kind of line between on campus and off campus is collapsing. Now, some people say that that's a reason not to support this topic, to vote for topic number one. I think topic number one is a lot better than this topic for more reasons that I'll expose, but I don't think this is kind of the death knell of the topic. I think there is kind of a conceptual difference between on and off campus, at least that occurs in the literature that you can use for your debates. Regulate. Regulate means to control by rule. The literature doesn't really use the term regulate so much, but it is talking about schools controlling what students say off campus on these online networks. And the way they control them is that they make a rule against the behavior and then they punish it. Through some school sanction, usually, out of school suspension or an expulsion for a semester, or even just a detention. Now, this brings up an important point because regulate used to be used more in policy debate resolutions, but people stopped using it because it essentially made the topic bidirectional. Now, what do I mean by that? It means that the pro could either argue for kind of more regulation, a stronger regulation, allowing schools to have more authority over what's said online, or they could have less. For example, in this context, the courts now say that there has to be a substantial negative impact on the school environment for schools to be able to regulate the speech that occurs, online speech that occurs off campus. But the pro could argue for any impact on the school environment, like that allows regulation. So if the speech has any impact at all, then what they could say is that would justify a regulation. The schools having a regulation on online speech. Now that would be still kind of traditionally pro the way we're looking at this resolution, and saying that there would be more regulation. But look, the pro could also argue kind of like for a softer role, that like it would have to have a massive impact on the school environment, and say, okay, well, in order for the schools to regulate it, it would have to have a massive impact on the school environment. Or, as we'll get into later, you could say the only type of speech that schools should be able to regulate is speech that's a true threat, which would make it, those two things would make it very difficult for schools to regulate free speech. And then on the pro side, you'd have the free speech argument. So see how a crafty negative, a crafty affirmative that's still topical could really kind of argue the opposite side of the topic and still be topical, which I think, public forum debate, we generally kind of want the straightforward, unidirectional, single direction resolution, which we've really even moved to in policy debate. So that is another problem. I think that with this topic that regulate can be bidirectional. But let's get back to the resolution itself. Remember, resolved, the United States public K-12 schools should be allowed to regulate students' off-campus electronic speech. The pro has to defend the status quo regulation, as I said, or a different regulation, which could be stronger or weaker. I think most terms, pros will either defend the status quo regulations or a stronger regulation, but I see no reason based on the wording of the resolution why they couldn't defend a weaker regulation. The pro will generally defend action against cyberbullying and or the protection of school security. The con will defend the First Amendment, free speech, and they'll also defend parental rights, which just simply means that parents ought to be the ones who decide what their children do and don't do on the internet. The con job, I think the con has the harder job because very few people say no. The school should not be able to regulate off-campus electronic speech. I've only really found one source, one law review article that says that they shouldn't be able to do this unless it involves speech. They shouldn't be allowed to regulate students' off-campus electronic speech unless it involves speech that is not protected by the First Amendment, such as intentionally and meaningfully threatening speech, which is not protected by the First Amendment. Obviously, not really controversial to say that a school should be able to regulate that. If somebody threatens to blow up the school, and that's a serious threat, then they should be able to punish the student. There's really not a lot of disagreement there. So, that article is the one article I found on the con. I've also kind of referenced another dissent by a judge in a court case where the judge says they shouldn't be allowed to regulate electronic speech. It's certainly possible that there could be a few other things out there, but almost every article concludes that the United States public K-12 schools should be allowed to regulate off-campus electronic speech, and they just get into the question of how it should be regulated, under what standards it should be regulated, what's fair, what's a good balance between the needs of the school and the needs of free speech. But let's kind of move into some background related to the topic. Debating this topic is about interpreting the Constitution and relevant Supreme Court cases. This is different than the probable cause topic because the Supreme Court has already ruled that probable cause is not required, for student searches in schools. It's said you don't have to have probable cause, you just have to have reasonable suspicion. The Supreme Court has said nothing directly about online speech. So in the probable cause topic, at least the Supreme Court's already interpreted the Constitution and other Supreme Court cases to come to this conclusion. The Supreme Court's said nothing directly about this. So we need to look to a couple places to interpret things and come up with arguments ourselves. The first is the First Amendment. The second is Supreme Court cases that are related to the question of student speech but aren't directly about online speech. So the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, as I pointed out, it says Congress shall make no law. It doesn't say the private sector can't restrict. Again, this has to be interpreted. The amendment doesn't say anything about schools or online activity at all. Of course, it would also be silly to interpret it as an absolute prohibition. Even though it says Congress can make no law, obviously it wouldn't be protected speech to communicate threats and to threaten people. And if somebody tried to arrest you, say, well, I'm allowed to threaten to kill them. That's part of my First Amendment speech. Again, you can't do things that disrupt things. You can't yell fire in a crowded theater. There are also kind of restrictions related to time, place, and manner of speech. that are kind of just appropriate, that certain speech is appropriate in certain places and certain times and in certain manners. Okay, so there are restrictions kind of on a person's free speech. So the question is, how do we apply, what type of restrictions are fair to allow in the context of off-campus electronic speech? Now, what has the Supreme Court said that's arguably relevant? Well, in Tinker v. Des Moines in 1969, the Supreme Court said that students have free speech in schools. Okay, it's not as extensive as what people have out of schools, but students have free speech in schools, and that schools can only regulate it if the speech presents a substantial disruption to the school environment or really threatens the rights of other students. Now, in determining whether or not a school was justified in restricting online off-campus speech, and so there have been many cases where schools have punished students for engaging in online off-campus speech. What district courts have done, since the Supreme Court hasn't ruled, and so what they've done is say, well, did this online off-campus speech create a substantial disruption in the school, or was it reasonably foreseeable that it would create a substantial disruption? And basically, in the cases where the schools were not able to prove that there was a substantial disruption or a reasonable foreseeable chance of a substantial disruption, the district courts have concluded that you can't violate, you can't restrict the speech. It's a violation of the First Amendment, that speech is protected because it didn't provide any disruption. And then they've said, where it did provide disruption, or realistically threatened to provide disruption, that the schools were allowed to regulate it. That's kind of basically really how most of the district court cases, shape out. Now, as I mentioned earlier, the debate in the literature is really not so much should schools be allowed to regulate online off-campus speech. The debate in the literature is, should there be a new standard other than substantial disruption? How should we define a substantial disruption? They say the court should kind of issue some guidance on that. Then maybe we should really rely more on the second prong of the test, especially when looking at cyberbullying. We should look at more whether it threatens the rights of other students. In hardly any cases did the court really consider the rights of other students. They mostly looked at the substantial disruption to the educational system. Then there are a lot of articles talk about how to write compliant policies. How do you write a policy that is designed to prevent cyberbullying that won't get struck down by the court? So this is kind of a lot of where these, this is what's discussed in a lot of the law review articles, not so much, and even just a lot of articles, not so much the pro and con of the topic. But since we have to debate the resolution as is, let's look at the pro arguments. The first is I've identified as cyberbullying. This has kind of become a big problem that students are harassing, Johnny goes home and then Sally and Peter start harassing Johnny online through text messaging or email or social media posts or posts on Facebook. There's a lot of problems created by this. It's obviously disruptive to the school environment. It causes a lot of emotional problems in students. Some students have even committed suicide. Generally, it's disruptive to school security and kind of the order within the schools. Now, the pro will probably want to make a framework argument that kind of mentions the role of the school, that it's important, that education is a very important part of society, that it's critical to democracy, it's critical to human development, and that we should really prioritize creating safe learning environments for students in schools, and we should prioritize education. Those are really impacts to the first two arguments, but can also be used as a framework argument. Of course, the pro will also have to answer the First Amendment argument, arguing it's limited in schools, that now since there's kind of a narrowing gap between on and off campus speech, that the home becomes an extension of the school, so that's relevant to there. You can kind of remember the fundamental impact to the First Amendment is democracy, so if you can argue that education isn't critical to democracy, you could say there are other limits on rights in schools, such as, the Fourth Amendment rights. If you've read about the probable cause topic, that makes that obvious as just one example, and that we are dealing with minors here, and the school itself is responsible for minors and therefore can't kind of restrict their speech. For con arguments, these are pretty straightforward. We're talking about the First Amendment, the freedom of speech. and how it shouldn't be constrained, especially like if the pro, think about it, the pro is that you really think that the resolution or part of your framework argument on the con is that the pro has to defend saying, no, we should completely, have a lot of authority over schools. The government, the school should have a lot of authority, over online speech. That this would really lead to a lot of restrictions on the First Amendment, really threaten freedom. You can say that it's important to parental rights, as I mentioned earlier. You can say that it's important for the parents to be able to decide what students do online. For framework, you really want to talk about the importance of free speech, the importance of students having rights in schools, the importance of schools kind of cultivating an overall sense of civic responsibility, not creating a lot of hostility between students and the schools. You do need to answer the cyberbullying argument, which is tough because cyberbullying is a very significant problem right now and there's a big impact to it. You want to talk about how there's other ways to solve it, that schools are adopting programs that don't violate the First Amendment, and that regulating online cyber speech is going to fail anyhow. You want to answer the school environment argument by arguing that, hey, one web page is not really going to undermine the overall disciplinary apparatus of a school. You have some random kid making some inappropriate web page, making fun of a teacher. It's not, if the school is kind of stable and well run by the administration, then this one thing should not disrupt the overall school environment. In terms of research, as I mentioned, most of the, you can look into the law reviews and you can definitely find some pro and con evidence in there, kind of on both sides, kind of making general arguments. But remember, the focus of the law review articles, with only a couple exceptions, is not really to debate out the question of the resolution. It's more to come up with policies and standards for when and how schools should be able to regulate off-campus online speech. So these law reviews, you kind of need to skim through them and learn about the court cases that are relevant and grab some relevant pieces of evidence. But they're not going to be as card intensive as other articles, say, like on the probable cause topic. The second thing you want to do is you want to look at some of the district court cases, because I mentioned this issue has come up on a number of district court cases, and some of these cases have found that no, there was no First Amendment violation, that the schools were justified in regulating the speech. Now, often in these cases, they're just saying there was no substantial disruption. That's why the First Amendment violation was not justified. So again, even these court cases are not like yes, no court cases. They're not saying, yes, schools should always be allowed to regulate off-campus speech or online off-campus speech, or no, they should never be allowed to regulate online off-campus speech. But in here, you kind of find some evidence that pertains to those general arguments. In a couple cases, there was a judge who kind of took a strong position on one side of the debate or the other. And then again, like here's some cases on the opposite side, held that there was a First Amendment violation. And in these cases, there's some additional briefs from the ACLU, the American Civil Liberties Union, making like a strong argument in favor of the fact that there was a First Amendment violation and the First Amendment should be protected. There's an essay on my website on millennialsd.com that kind of contains a lot of the content of this presentation, but also links you directly into these court cases on one side or the other, and also a lot of law review articles to help support your research. But in conclusion, remember, we have resolved the United States public K-12 schools should be allowed to regulate students off-campus electronic speech. The resolution is simpler than the probable cause resolution. I know some people are just like, I don't like the probable cause resolution because it's probable cause in it, and that's a legal concept. But the issues are more complex on this topic because A, there's no settled law, as I've explained. Okay, Des Moines v. Tinker was a case about regulating speech in schools. District courts, since there's no Supreme Court case about regulating speech outside of schools, all right, have applied the Tinker test. But there's no real settled law in the area. A lot of the district courts wish the Supreme Court would grant cert to one of the cases before them and try to resolve this issue and make a ruling as to whether or not the Tinker standard should apply, if a different standard should apply, all right, if it's just kind of completely legitimate or not legitimate. out of the gate. But there's kind of a lot of ambiguity in the literature. And as a result, most of the literature isn't about the resolution in terms of, making strong arguments on one side or another. People accept kind of that the Tinker test governs, that the status quo, all right, that the pro is acceptable, and that it's just about determining how schools should go about regulating online speech, which is not the question in the resolution. And of course, this kind of makes it pretty difficult to be con. I would choose to go pro and just kind of defend the status quo and let the negative read. For evidence from the one article I found, maybe another judge's dissent, maybe a couple of amicus briefs. So it's not even clear that the ACLU is going to take that strong of a stance and say no regulations at all. Because look, and people are aware that the line between off-campus and on-campus speech is collapsing in the cyber world, that cyberbullying is a significant problem, and that school administrators do need to kind of be able to regulate and establish order in their schools and deal with external threats to the school environment. Their responses have to be reasonable, but it probably is not very reasonable to say that schools should not be allowed to regulate online speech that occurs off campus at all.